Welcome to Consumer Law, What Is It Good For?, where we look at, consider and try to answer frequently asked questions put to us here at Stormcatcher Law through our legal advice helpline or from clients. And in this video, I'm going to look at business vehicles and in particular what you can do if you've bought a faulty vehicle, whether that's a car or a van, for your business by way of a lease or unregulated hire purchase or contract hire. Now, by way of an explainer and a bit of an introduction, this video will relate to people who are sole traders in partnerships and limited companies who have purchased a car, a van, a truck, a tractor, or any form of machinery on finance for business use. Importantly, these are cases to which the Consumer Rights Act 2015 does not apply. And the reason that I mention that is almost every question that I've had about this subject, the questioner quotes the Consumer Rights Act. And in all fairness to them, I've had any number of letters from finance companies, car dealerships, and from their respective lawyers that refer to the Consumer Rights Act. And in fairness again to them, in researching this video, I asked AI what to do about a faulty vehicle bought on a business lease. And I received the answer that the Consumer Rights Act 2015 applies. To be clear, it doesn't. The reason for that is that the Consumer Rights Act applies specifically to individuals, and companies, limited companies and partnerships are not individuals. And even if you are an individual, a sole trader from that point of view, the Consumer Rights Act does not apply to circumstances where you bought a vehicle which is exclusively or mainly for your business use. So, when we look at complaints and disputes involving vehicles that's been bought on finance, we need to go through a very similar process that we do for all of our disputes. We need to identify what the problem is. We need to identify what the cause of action is. We need to review our contract, which in this case is going to be our finance agreement, and then we need to make a plan of what to do next. So I'm going to go through each of those stages individually, and let's see how we get on. So stage one, we've got to identify what the problem is that we're complaining about. You, and it's going to be exactly the case with every other legal dispute, you are going to bear the legal and evidential burden. So you've got to prove your complaint. And in relation to vehicles, we're looking at faults, we're looking at descriptions, we're looking at hidden history, issues, whatever that may be. You need to provide documentary evidence. Documentary evidence is going to be diagnostic reports, expert reports, information that proves precisely what you're talking about. Now, you can do this, for example, if your vehicle is currently with a mechanic or a main dealership, you can ask them for copies of all the job sheets, repair invoices, estimates, diagnostics, etc., that they have in relation to your vehicle in general. You may have taken it to the same place since you've had it, and of course in particular to the current issue. Okay, so you're going to look at issues that you may have historically, if there's been a continual pattern of different repairs, and you're going to need evidence in relation to the current problem. It's not going to be enough to say this light has come on 5 times before. This is the fault code that was related to that light. It's come up again, therefore it must be exactly the same as the problem that we've had before that people have failed to repair. That's not going to work. You may need expert evidence, and that's going to involve perhaps going online, looking at the Institute of Automotive Engineers, looking at a suitably qualified and experienced expert in the field that you're looking at and within your area. You can obviously call us and we can give you a few recommendations. And you may also need, or it may be worthwhile having, either, depending on the problem, a fuel and or an engine oil sample analysis. And again, you can give us a call. Lots of different firms around the country offer that laboratory forensic analysis, and it can be incredibly useful, and it is incredibly inexpensive. Number two, we've got to look at all of that evidence. So we have to have all of that evidence first before we can proceed to stage two. And then we've got to look at what the evidence and the facts tell us about your potential complaint. What does it point to? Is there some sort of mechanical failure, which because of issues around durability and satisfactory quality may automatically lead towards a claim for breach of contract? Let's just use that term at the moment. It could be a misrepresentation if the mileage isn't genuine, if the service history isn't genuine, if it's been involved in a collision previously, has it been sold through a salvage auction? Those things could amount to some form of misrepresentation. And again, prima facie, the finance company, because that's who we're directing our complaint to, would be liable for breach of contract. It is possible that the supplying dealership may also be liable in negligence for some form of misrepresentation if they've misled you. But I stress this is all fact and case specific. Okay? Now, number three, hopefully by this stage we've got evidence. That evidence points towards some sort of legal cause of action. Breach of contract, negligence, misrepresentation, and so on and so forth. At this stage, once you've got that, we have to review the contract, or importantly, the finance agreement. The finance agreement will almost certainly be headed with the words, "This agreement is not regulated by the Consumer Credit Act 1979, because it's not a consumer agreement." And this means essentially that whatever happens, you will not have the right to escalate your complaint to the Financial Ombudsman Service if you do not like the outcome that the finance company gives you. The next thing you have to do is you've got to look at your finance agreement, and you're looking for specific clauses. These contracts are pretty long. It tells you what you have to do. It tells you what they have to do. But what you're looking for is something that will usually be subheaded as a limitation of liability clause or exclusion of liability. And I'm going to read an excerpt from one in particular to give you an idea of what you're looking for. I quote, "Since the vehicle has been chosen by you and not inspected by us, we do not give any representation or undertaking, express or implied, as to the condition, description, quality or performance of the vehicle, as to its fitness for purpose or any particular purpose, and all such representations are specifically excluded." It's pretty wordy, I appreciate that. In short, in common sense language, this clause is intended to exclude liability under the Supply of Goods Act 1973, which is all about supplying goods on finance, and pretty much every other piece of common law or statute or misrepresentation. It is designed to exclude pretty much everything. Now, that does lead to a lot of people saying to me, so what you're saying is that these people can basically sell me something that looks like a car, sounds like a car, but has no relationship to a car. It could effectively be a steel shed on wheels, and they can get away with it. Well, at face value, yes, that's what it seems to do. So the purpose of it is to look at your existing claim, that we've used those building blocks to get this far, and create a barrier that prevents you from enforcing it. Now, I would suggest that the vast majority of businesses and finance companies that utilise limitation of liability and exclusion clauses are banking on people accepting that that is legitimate, it can be enforced, and that they can get away with it, if you like. But like everything in life, there are exceptions. So we move on. So obviously, if your contract does not include a limitation of liability clause, and this may happen if they're non-finance agreements, you'll struggle to find one finance agreement that doesn't include that. But in other business contracts, auction, if you bought a vehicle from an auction, you may find, for example, they don't have these exclusion clauses. Then great, you can proceed with your case and your claim under Sale of Goods Act, for example, or any other legal principle. If it does include this exclusion clause, do not immediately lose hope. Okay, and the reason for that is that whilst it is challenging, difficult to overcome contractual terms, it is very much case specific. And the common law, that's case law, court cases, have evolved to look at what the exceptions are to these rules. And I'll give you an idea. One has to consider, for example, whether you, the buyer of these defective goods, are left without any remedy or cause of action at all. So if you don't have a warranty, for example, because one wasn't supplied with it, or the warranty has declined cover because they believe it was a pre-existing issue, you would effectively have no recourse whatsoever if this exclusion clause was found to be valid. The second thing the law looks at is the bargaining positions. And in most cases, you're a business, whether a one-man band, a partnership, a small limited business, that you're not going to have, I'm sorry to say, the same resources as an international bank. They're going to be far wealthier and would have had and bought and sold far more cars than you have. And the chances are they'd have come across the problem you have with this vehicle, truck, van, or otherwise many, many times before. So the bargaining position, your position vis-a-vis the bank, is important. We also need to consider whether the terms that are in your contract, whether they were individually negotiated or are they a standard contract. I can assure you, in 99% of the occasions, you're going to be receiving the same contract as everybody else. You may not have read it. That's not something we can excuse. You may not have understood it. That's a different issue. But it would not have been individually negotiated between you and the finance company. Now, we have to look at all of these things to consider whether or not you've got an opportunity of rendering the exclusion clause invalid. And the good news is, from your point of view, is that the burden of proof, unlike with the evidence of the faulty vehicle, the burden of proof of establishing whether these exclusion clauses are reasonable, which is what the law considers, rests with the finance company. So you've got that sort of reverse burden of proof as far as that's concerned. In regards to the possible head of claim or cause of action against the dealer, which is in negligence, again, you need to look at their terms and conditions. Do they have what's called a non-reliance clause that disclaims any liability for anything they've said or done? Are they able to effectively promise you the earth and deliver you nothing? If they don't have those terms and conditions, you may well have a cause of action, albeit in money, in negligence, against that dealer. It will be compensatory. It's unlikely, but not impossible, that it will be enough for you to reject your faulty vehicle, but it may go some way of making up the difference between a warranty claim, for example, or compensating you for the aggravation you've had. Again, very much case specific, but you have to make sure you have a case in order for somebody to try and exclude liability first. Don't just look at the contract and give up. You've got to go through these building blocks. It takes a bit of time. It may cost you a little bit of money to get some professional advice, but it may prove to be worthwhile. I hope this video has been helpful. If you have any questions, please contact us at Stormcatcher Law. Email us at knowledge@stormcatcher.co.uk or call us on 0333 700 7676.